Hello. So you ended up in immigration court and you're trying to find out if you're going to win your case or how to get out of immigration court. Well, this video is for you. My name is Jorge Molina. I am an immigration attorney based in Dallas, Fort Worth. And today we're going to be talking about getting out of immigration court or winning your case in immigration court. Before I go into those details, I also need to give you some updates, and not only for our clients, but our future clients or people interested on this information. We strongly believe in empowering you through information. So there's three major updates that I need to make everyone aware of. And the first one is that TPS for Venezuela was extended, which is fantastic news. The administration waited until the very last day to announce that it was extending TPS another 18 months. However, the administration did not expand the eligibility for TPS from Venezuela. That means that you still need to fulfill the requirement of having been present in the United States March 9th, 2021. Okay, so that's the first thing. However, we're still waiting on guidance from immigration to let us know what are we going to do with cases that have been pending with immigration since the first TPS designation was announced. So as of right now, if your case is pending, we don't know if CIS would want you to reapply. So it is extended, or since it's pending, they're going to assume that you're reapplying and they're going to grant you TPS for that renewed period. So we're still waiting on guidance from CIS on this regard. And importantly, the great number of TPS cases remain pending. Now, while I know a lot of people say, well, my case was approved and everything, the great majority of people are still waiting on their cases. So this has happened with our own office. So I would say maybe about half have been approved, about the other half is pending, but we don't know what we're going to do with those cases that are pending yet. We're waiting for CIS guidance in this matter. Additionally, Daca. So a few weeks ago, we had the oral arguments before the Fifth Circuit Court. It was a particularly right-wing panel that heard the government's arguments and the state's arguments. Interestingly, there was a Supreme Court decision regarding the migrant protection protocols just issued a few weeks ago, which might have a big impact on how the court would rule, because pretty much the Supreme Court said, the administration has the authority to designate under its wide array of first, international policy, and second, its enforcement mechanisms. So perhaps we get a negative result from the Fifth Circuit, which would prolong the stay, or the Supreme Court will intercede before they issue a decision. But just stay tuned. Some news should be coming from Daca. We expect a decision from the Fifth Circuit in a few months. And lastly, regarding prosecutorial discretion, importantly, just keep filing. Okay, so if you're unsure whether ICE could issue a decision based on prosecutorial discretion grounds, ICE or DHS just came out recently saying that they are still considering those. So my policy is to keep filing, and if we have a good case, that's the best course of action that we can follow. But anyway, those are the updates. Now let's get back to the topic at hand, which is we're in immigration court. So we've been talking for a series of weeks now on how you end up in immigration court, who's deportable, who's removable, what are the grounds of deportation, and what are some of the defenses. But now we're going to talk about, what to do once you're in immigration court, right? And first, I'm going to address what you can do as a lawful resident, and then we're going to talk about your options if you're not a lawful resident. So here's the first option. So you ended up in court. Let's assume you committed an offense that made you deportable or removable. So what do? Well, the quintessential defense in immigration court is cancellation of removal for lawful residents. There's a few requirements here. So first, you cannot have been convicted of an aggravated felony. Second, you must have been a lawful permanent resident for about 5 years. And third, you must have resided in any status in the United States for 7 years. There's a few distinctions in that point that's somewhat outside the scope of this presentation, but those are the requirements. Additionally, there's a discretionary consideration. So pretty much if you meet the elements, you still need to prove to a judge that you still merit that exercise of discretion. And this is a very important ground because many cases, they meet the elements, the offense doesn't seem that serious, but the judge would look at the whole picture and say, you know what, you don't merit it. And in particular, this happens in drug cases. So if you have a long history of possession of drugs, or you've been dealing with drug addiction, and because of that, you have a long history of, being caught with drugs by law enforcement, the tendency, and again, the immigration court system and the appellate system in the immigration context has been criticized for treating those cases as, or just denying those cases routinely. But, that's a first offense, cancellation of removal. Again, if you don't have an aggravated felony and you've been a lawful resident for 5 years, live in the United States for about 7, and that you merit favorable exercise of discretion, you can request cancellation of removal. Now, the other, now it's not so common, but it has been it had been for a very long time. It was a I-212C waiver, which is a predecessor for the cancellation of removal that I just mentioned. The thing is that the law changed in April 1st, 1997. So for practical purposes, the only people that would consider or that would be eligible for a 212C waiver would be individuals who had a conviction dated before April 1st, 1997. Now, there's a few differences because, the law was changed between 1990 and 1996, and then again between 1996 and 1998. So there's different provisions depending on your circumstances. However, for our purposes, as long as you had a conviction before April 1st, 1997, this form of relief is available to you. There's other considerations and other things that you need to prove. You must show that you're a lawful resident and that you have lived continuously in the United States for about 70 years. And you also need to show that you merit a favorable exercise of discretion, right? So similar to cancellation or removal, while these cases are not as common as they used to be, we're still seeing them in court. And then finally, the other defense that you could have in immigration court is adjustment of status. Now, usually adjustment of status is done with Citizenship and Immigration Services, and most immigration courts would want you to resolve that issue if you have a clean adjustment of status case with Citizenship and Immigration Services. So most of the cases that you're doing adjustment of status in immigration court require a waiver because you were convicted of an offense. So for this, the waiver the most common waiver is the 212H waiver, which waives a series of things, but mostly criminal activity. Now, I would like to illustrate the limitations of the I-212H waiver with a few examples, but first, let me tell you who would qualify. So anyone who has been convicted of an offense listed for grounds of inadmissibility relating to either crimes involving moral turpitude, criminal activity, multiple convictions, a sentence of over 5 years, etc. And this waiver is limited to either people who have been able to show rehabilitation and the conviction has been over 15 years from the date that you're requesting it, or denying the waiver will result in extreme hardship to a qualifying relative, so spouse, children, parents, or you're a victim of violence. But mostly it's, you need to prove extreme hardship, but there's a big caveat here. And this waiver is not eligible for individuals who had been a lawful resident for less than 5 years and who entered the United States through consular processing. So let's say pretty much your green card was approved in a consulate or embassy abroad, and then you entered the United States as a lawful resident. So it's not allowed in those situations. So let me illustrate how, in my opinion, misguided those limitations are, particularly in, for individuals that enter lawfully to the United States. So let's say you have two brothers. One is a lawful permanent resident and has been for about 3 years. He got his green card through marriage. He used to live, let's say, in Mexico, and they filed all the paperwork in Mexico, had no crime, nothing, and he entered lawfully to the United States with a green card. Then there's his brother. His brother entered the United States lawfully with a tourist visa, but overstayed. He has been in the United States, for about 5 years. He's not married to anybody, but he has a longtime girlfriend. And then they're both caught stealing, very valuable items. So they're charged with grand larceny, and they are sentenced to over 1 year of jail time. It is a suspended sentence, and they're given probation. Now, they both end up in immigration court. So the second brother, he realized that, he's in big trouble. He ends up marrying his longtime girlfriend while in jail, and he's able to file a family petition through the girlfriend, then an adjustment of status with the waiver, and he proves his case, goes to immigration court, shows that he merits a favorable exercise of discretion, and he's granted a green card. So that's the second brother, the one that had no lawful status. Whereas the first brother will go to court. Let's say he would have someone else who could petition. Let's say he became a lawful resident through a spouse, but he also has a 21-year-old U.S. citizen child that could file for him. And he goes to court and says, I want to file for readjustment. And he's ineligible because he entered the United States through the consular process, and he cannot file for a waiver. So the only thing that he can get is an order of deportation. So, details matter greatly. In some cases, you would think that you would have a better chance than in others, but the law is just counterintuitive. So if you find yourself in this situation, or if you're in immigration court, if you want to know whether you can apply for cancellation of removal, a I-212C waiver, or adjustment of status, call us. We'll be happy to assess your case and let you know if you have a defense. Now, if you're a non-lawful permanent resident, you can also apply for cancellation of removal. However, it's much limited. So instead of showing that you've been in the United States for 7 years, you need to show that you've been in the United States for 10 years. You must also have a qualifying relative. A qualifying relative in this context would be a spouse, children under 21 years old, or a parent who are either U.S. residents or U.S. citizens. And you must show that your deportation will result in exceptionally and extremely unusual hardship to your qualifying relative, which is a very high standard. Additionally, you cannot have been charged or been convicted of an offense listed as a ground of inadmissibility or a ground of deportability. So, even if you're convicted of a crime involving moral turpitude that could fall within the petty offense exception, if it was for a crime that could potentially carry a sentence of 1 year or more, so for example, in Texas, a misdemeanor class A, you wouldn't be eligible for cancellation of removal. Additionally, you cannot have been convicted or found inadmissible or deportable for terrorist on terrorist grounds. So, very limited, very few convictions that would still allow for non-LPR cancellation of removal. So that's one option. You also have the possibility of adjusting status if you have a lawful entry. So that's a catch, right? So as long as you have a lawful entry, even if you had a long period of unlawful status in the United States, and you have a qualifying relative who would, so let's say a spouse or a child over 21 or U.S. citizens, you would be able to do an adjustment of status even if you were out of status in the United States. Additionally, there's other things you can request. So, for example, VAWA, which is protection for victims of crimes at the hands of U.S. citizens or lawful permanent residents, or a U visa for individuals who are a victim of crime. And again, you could also request withholding removal or asylum, but those are extremely difficult cases to win. You can still make the case. You must have a meritorious case. Some courts are a lot harder than others. The Fifth Circuit, the circuit we're in Texas, is a lot harder, but you can still make that defense. Now, if this is your situation, you don't know if all these defenses that I just mentioned, which one would apply to you, call us. We'll be happy to assess your case. My name is Jorge Molina. We're based in Dallas, Fort Worth, but we serve people worldwide. If you like this video or like our previous videos, please hit share, follow, and like, and we really appreciate it. Again, you can always reach us at 469-708-5800. Again, 469-708-5800. My name is Jorge Molina. Or you can send us an email at info@jmolina.law. Again, info@jmolina.law. Thank you for watching. Bye-bye.